All right, let's get to our guest speaker. We're going to do our Supreme Court review with Judge Tom Long, and our second VP is going to assist with moderating and question and answer. I think we're going to have, when he gets done with the presentation, we're going to have question and answers, and we'll move a mic around so that people on Zoom can also hear. Judge Long is a longtime member of Palos Verdes Democrats. He is a sitting Superior Court judge from 2015 to present. He was a civil litigation and trial lawyer for more than 33 years. He was awarded California Lawyer Attorney of the Year for litigation in 2014 and was recognized as a litigation trailblazer by the National Law Journal in 2015. He's a former two-term mayor and city council member of Rancho, Palos Verdes. So please welcome our own Superior Court Judge Long. Thank you.
Thank you very much. We're going to be starting the presentation in just a moment, and I wanted to introduce the panelists that you're going to hear from. Mario Barnes is a professor of law at UC Irvine. He's the moderator. Courtney Cahill is a professor of law also at UC Irvine. The famous, if you haven't heard of him before, Erwin Chemerinsky is currently the dean of the law school at Berkeley, and he was the founding dean of UC Irvine's law school when it was first created some years back. Jessica Clark is a professor at USC School of Law, and Mark Joseph Stern is a senior writer with Slate. And Louis, did you have anything you wanted to add before we got started?
Okay, just one moment. So I did want to say that this is an incredible presentation. The 15th annual, one of the most interesting ways to approach something. We have a panel of great experts, and then we have another expert here. So an analysis, one analysis, and then another analysis and a translation of what they're saying so that everybody can understand it. It's a really great idea. I'm really happy to be associated with it. So what I wanted to credit the people that put this together. Back going 15 years ago, it was like a great idea. Who came up with it? No one can remember. It's lost in the sands of time. But Tom was there. Maybe he will remember at some point. But
admit I don't remember either.
Yeah, isn't that weird? But anyway, putting it together this time was, of course, Tom, Carol Moeller, Reggie Jew, doing the technology, excellent. Ann Nye, and Ann said, be sure to credit yourself, Louis. I was there, but I was mostly watching. And then, of course, Tim Dixon, whose inspiring words, which you just heard, motivate and energize everything that we do. So what's going to happen is Tom's going to introduce this. There are going to be some excerpts that were selected by the team that a week ago put them together. And then there'll be commentary. And then at some point, Tom is going to ask for questions. At that point, I am going to take this microphone and I'm going to walk around like Oprah Winfrey. Everybody knows that modality. So, and at that point, I'm going to.
We don't have any cars to give away.
Yeah. Everybody, check under your seats. But we are going to try to think. If you want to make a comment, very concise. I don't filibuster, and I'm saying this as a person who's totally guilty of doing that. So I can see it when it's happening, but get to the question so that everybody can ask a question. Not only those that are here, but those that are online watching on Zoom. So I'm going to take the microphone and I'm going to sit over there, and then when Tom says it's time, I'm going to stand up, walk around, and get your questions. Go ahead.
Let's start with Professor Chemerinsky's overview.
Thank you. It's so wonderful to be here and great to be back home at UCI. I want to just quickly put this in a context. Every summer, I write a book for the American Bar Association that describes the just completed term. And I try to come up with a title that reflects a theme for the year. My title for this year is Taking Sides. Our country is more ideologically divided than it's been at any time since Reconstruction. There were so many cases this term that presented issues from the culture wars. There were challenges to President Trump's unconstitutional actions. The Supreme Court consistently took sides, coming down on the conservative side with regard to the culture wars, coming down on President Trump's side. And so I believe that the most important question as we think about the Supreme Court is at a time when our country is so ideologically divided, what does it mean to have a court that's come down so solidly and consistently on the conservative side? And I think it's in that context that I can talk about Trump versus Casa that came down on June 27th. On January 20th, President Trump issued an executive order to try to eliminate birthright citizenship in the United States. A bit of context here, too. From 1787, when the Constitution was written, it was always understood that everyone born in the United States was a United States citizen. Tragically, in 1857, in Dred Scott versus Sanford, the Supreme Court said that enslaved individuals are not citizens, even if born in the United States. They're just property. When the 14th Amendment was adopted in 1868, the first sentence was to overcome Dred Scott versus Sanford and to overrule it. It says all persons born or naturalized in the United States with the jurisdiction thereof are citizens of the United States. In 1898, in United States versus Wong Kim Ark, the Supreme Court said everyone born in this country is a United States citizen, regardless of the immigration status of their parents. The court said within the jurisdiction thereof just means if there's an invading army and the soldiers had children, or there's a foreign diplomat as a child, they're not citizens of the United States. No one had ever questioned that everyone born in the United States is a United States citizen until on January 20th, President Trump, by executive order, said only those who are born to United States citizens or those with green cards are United States citizens. 3 federal district courts clearly and quickly declared this unconstitutional. Each issued a nationwide injunction. The Federal Court of Appeals in each area upheld this. The Trump administration did not ask for Supreme Court review of those orders. Instead, the Solicitor General filed a petition asking for what it called, and I'm quoting, a modest request. It just wanted the Supreme Court to hold that nationwide injunctions are impermissible. The Supreme Court scheduled oral argument for Thursday, May 15th, and on Friday, June 27th, the Supreme Court, in a 6-3 decision, essentially ended the ability of federal courts to issue nationwide injunctions. Justice Amy Coney Barrett wrote for the court. Justice Thomas Alito and Kavanaugh wrote concurring opinions. Justices Sotomayor and Jackson wrote dissenting opinions. There is blistering dissents, as you'll find anywhere in the United States reports. Justice Kagan also dissented. It's interesting that Justice Barrett's majority opinion focused on the statutes creating federal courts. It wasn't a constitutional ruling. And she said, in order to understand whether federal courts can issue nationwide injunctions, we need to look to whether or not chancery courts in England could issue such injunctions. Justice Jackson responded to this by saying, in England, the courts couldn't stop what the king was doing. We shouldn't be looking to what English courts could do in the 18th century to decide what courts can do today. Justice Barrett said that nationwide injunctions are relatively new. She said the first one she could identify was in 1963. And she said, we're not going to pay attention to the context. We're just looking at the power of the courts. Justices Thomas and Alito wrote concurring opinions to say, let's not see things like nationwide class actions and suits by states take the place of nationwide injunctions. Justice Kavanaugh wrote an interesting concurring opinion saying, you know, just bring everything to the Supreme Court on its shadow docket. He literally said, we're open 7 days a week, 24 hours a day. Come to us. Justices Sotomayor and Jackson both saw this as a real threat to the rule of law. Justice Sotomayor said there have been nationwide injunctions at least since the early 20th century. She expressed concern that if there's not a nationwide injunction, then would you need to file a lawsuit in all 94 federal districts to stop a practice? She expressed real concern that a president could do something unconstitutional and just wait until each district struck it down, continuing the practice was not restrained. She talked about the practical consequences. So does this mean that 2 babies born under identical circumstances in 2 districts could have one a citizen and one not? And Justice Jackson said, once a court declares something unconstitutional, it should be unconstitutional. So how should we think about the case? To some extent, its importance is going to depend on whether or not nationwide class actions and suits by state governments can achieve the same goal as the nationwide injunctions. Obviously, some justices think so, but Justice Thomas and Alito very much said, don't allow these to substitute for nationwide injunctions. If they don't substitute for nationwide injunctions, then do we really get to a situation where there has to be a lawsuit in every federal district in order to stop a presidential practice or an unconstitutional federal law? And ultimately, I conclude with what both Justices Sotomayor and Jackson emphasized. At a time when we have a president who's repeatedly pushing the bounds of the Constitution in all the ways Mario suggested, what does it mean to have a court that's lessened the ability of the courts to check the president? At this moment in time, our guardrail of democracy is the judiciary. What's it going to mean to have the court so weaken the powers of the judiciary to stop the president and enforce the Constitution?
So thank you, Erwin. I will note that Justice Coney Barrett responded quite viscerally to what Justice Brown Jackson referred to as the existential threat to the rule of law, by noting that she wanted to replace what she saw as the imperial executive with the embrace of an imperial judiciary. So is that what Sotomayor and Jackson are essentially offering us in place of what they're concerned with as the overreaching executive?
I think what's interesting is that Justice Barrett's majority opinion says we're not going to look at context, whether or not we need nationwide injunctions to stop the president. We're just going to look at history. Is this a power that courts had in the late 18th century? Was what Justice Sotomayor and Jackson want to talk about is we have to look at context here, and we can't ignore this is about lessening the power of the court at a time we have a president violating the Constitution. I do think that Justice Barrett's response to Justice Jackson crossed a line. She basically said, I'm not going to deign to talk about what Justice Jackson has raised here. I think that there's been an increase in sarcasm and put-downs among the justices, and it's lamentable whether it's conservatives or liberals doing it, but I think that Justice Barrett treating Justice Jackson that way was regrettable.
Mark, you have thoughts?
I just wanted to add to that. I think that Justice Barrett's extraordinarily disrespectful response to Justice Jackson may well reveal some biases on the part of Justice Barrett about what kind of people are allowed to have opinions on matters of law. It seemed that Justice Barrett simply did not respect Justice Jackson's extraordinarily forceful and intellectual rejoinder, and yet Justice Barrett, when she disagrees with, say, a white male member of the court, somehow finds a way to afford a lot more respect. And I think that the bad blood that we're seeing emerge between those two justices may go deeper than just surface level substantive disputes over the law, and that the contempt that Justice Barrett showed toward Justice Jackson was quickly picked up upon in the conservative media, in the press, in the political sphere. There has been a pile-on Justice Jackson, accusing her of being a mediocrity, accusing her of being an affirmative action hire, all of which is fueled by Justice Barrett's response, and I think that she owed her colleague much more consideration than to lob a dig that was quickly picked up upon by racist, sexist forces to encourage a misogynistic and racist view of Justice Jackson's intellect.
Well, I think one of the more outrageous claims I read in the last few days is how dare Justice Brown Jackson have the audacity to write a solo dissent, given her newness to the court, almost so that she should sit in deference and learn something by being on the court before she deigned to voice any opinions for which there are no others who join her, which I find, I've never heard that before. I mean, I've never heard it suggested that you're not immediately qualified to speak on the matter.
Would you say there's maybe a double standard?
I would not say that, because I cannot absolutely, prove it, but it certainly seems to be a problematic.
We at the break point?
That was it.
Oh, very good. Okay. So I wanted to stress that I think, and I'm certainly going to want to hear some thoughts from people's questions and comments, but this is rather loud. How am I messing up the feedback here?
You have to turn it down.
No, they'll do it.
Oh, okay.
Oh, it's, yeah, soft.
But this, of all the cases we probably had that we've ever discussed in any of these presentations, this is probably the worst case ever. And I say that I'm sure a number of you have heard of the Marbury versus Madison case, in which the court held for the first time over 200 years ago that yes, the Supreme Court had the power to declare the actions of the legislature and of the president to be unconstitutional. And effectively what this is saying is, well, yes, the Supreme Court and the other federal courts can declare the actions of the other branches unconstitutional, but only in the specific cases in the specific parties involved. So if hypothetically, for example, or I guess it's not hypothetical, the government were to start rounding up people just based on the fact that they're allegedly not citizens or they're Hispanic or whatever, round them up, send them off to a country in Central America that's run by a dictatorship, or send them off to Africa where there's another country in the midst of a civil war, and just do that, you'd have no right to put a stop to it for anything. No federal court would have a right, none of the lower courts would have a right to put a stop to it, except in the precise cases and those few individuals who actually manage to get lawyers to help them and get the lawyers to help them before the people are actually deported. So it's singularly probably the worst decision, because it reflects not only a bad outcome on birthright citizenship and the idiocy of different rules. People would be citizens in some districts and not citizens in others, which makes no sense whatsoever. But it goes beyond that. It could be anything the government does, the legislature or the executive in particular does, anything that is unconstitutional. And you have to traipse around, as Professor Chemerinsky was pointing out, traipse around to all 94 federal district courts to try to get rulings that would put an end to this. And it's just, having read Justice Jackson's dissent, I don't think she could have stated it any more accurately than she did. And if it was forceful and objectionable to Justice Bennett, it's probably because Justice Bennett really hasn't thought through all of the issues. Yes, it's true that you can have, you can have the view that the courts are really supposed to first and foremost be dealing with disputes between parties. And to some degree that's true, but to say that the Supreme Court, to say that the lower courts and the federal courts in general, I guess until you finally get to the Supreme Court, but it's unclear, to say that the federal courts simply can only adjudicate particular disputes involving particular individuals is very limiting. Now, we won't know until we see how this plays out in future situations involving class actions, exactly how bad it is. And since this decision is based on a reading of the Judiciary Act and not so much a reading of the Constitution, it's possible that the laws could be reformed in the future. But this is an extremely bad case. During all the years I've been involved in this review of Supreme Court cases, this is the most damaging because it's not confined to the issue it addresses. It has much broader ramifications. Does anyone have any questions before we proceed to the next item? We have a question over here, I think, a couple of questions over here.
Could I get your name first?
Carol Moeller.
Thanks.
I know this was a birthright citizenship case that morphed into something
Morphed
else.
into no nationwide injunctions,
Yeah.
right?
So is that the final word on the birthright citizenship.
No, it can't be. And I think the court would have to admit that. And I still think there are no serious legal thinkers out there who believe that the interpretation of this administration regarding birthright citizenship has any merit whatsoever to it. So I think as, when, and if the issue gets teed up, it's going to be decided still in favor of birthright citizenship. But then I could be wrong. If you had told me that the Supreme Court was essentially going to overturn Marbury versus Madison and hold that the entire judicial branch can only issue orders in connection with specific individual parties in specific cases, I would have said that makes no sense. Things haven't been like that for hundreds of years now. That makes no sense whatsoever. And yet, here we are.
Your name, please.
Yeah, David Bentz. Tom, have any of the class action, state court actions been proceeding along the lines to try to give some
well, I can't, as a state court judge, if there are state court class actions, which I'm not aware there are, I can't comment on any of them. But the questions here primarily involve questions of federal law. So even if a state court, even if a case on this nature might be brought in state court to start off with, the issues would pretty quickly end up in federal court because it's an interpretation of a question of federal constitutional law, whether someone is a citizen or not. We have a
So I'm not a lawyer, but I did.
I'm not either. I'm now a judge, so I'm not a lawyer. So I'm not giving you any legal advice whatsoever.
Take 2 con law classes, and my experience of it was that I almost think Marbury versus Madison and some of the older cases are a source of an empowerment that's creating some of Citizens versus United in this case, that sometimes we're allowing too much power, like in the shadow dockets or whatever, from my unique, very limited observation.
Well, I'm glad you raised that.
I was 60s.
Yeah, I'm glad you raised that. The shadow docket is an issue and it's a problem. The Supreme Court is doing fewer and fewer opinions every year, fewer cases, fewer written opinions, and deciding things without actually writing up their reasoning. But then what they're doing creates no precedent.
And their citation, well, first of all, we have very few cases because everything's mediated, but we're citing all the way back to the 18th century for Roe v. Wade, when women not only didn't have the vote, they were considered property, as were their children. So we're going so far back for the Supreme Court right now cases.
Well, and the Supreme Court is, it's arbitrarily focusing on history. It also, and I think one of the commentators mentioned this as well, which I find rather interesting, the concept that we have to look to the late 18th century for whatever our rights are supposed to be, and that at that time, the courts didn't have power over the other branches because that's not the way England was structured. Well, the purpose of the Revolutionary War was to separate us from England. We didn't want to have the House of Lords being the top court. We didn't want to have a court system that was answerable to the monarch. And so we made changes, and we get amateur hour history from Justice Thomas, who thinks he understands history. But the reality is we don't really know what the intent of the framers really was because we have only very fragmented records.
Why are we limiting who we have running for office?
If you're talking, they can't hear you on Zoom.
You need to speak into the mic.
What we need candidates that are saying things like, we need to reform the Supreme Court itself, not add 10 judges, but we need laws that guide them to not do things that are really destructive, and just a candidate that would run on that and
well,
people.
There's no easy, it's probably beyond the scope of what we can discuss today, but there's no easy way to reform the Supreme Court short of a constitutional amendment. And I'm not sure you'd like to see the amendment that, say, a constitutional convention might come up with. Or that the current Congress might come up with. So it's has a host of problems with it. But we tend to look too much at history, and I think you're right, your comment about Roe versus Wade. We tend to look too much at history when we really don't know what was in the minds of the 9 state legislatures that ratified the Constitution when it first took effect. We don't know what was in the minds of people other than the small number of people who wrote the Federalist Papers. And to try to come up with a view toward, and with a view that starts with the premise that the founding fathers would have wanted us to freeze everything at the particular moment in time that the Constitution was ratified. I don't think they would have wanted that. I think they would have wanted us to understand and interpret things as they go along. And certainly, I don't think the founding fathers would have thought we would be facing situations like we're facing now, like birthright citizenship being denied, like people being sent to foreign countries with little or no due process. No one would have anticipated any of that. But if you want, and I'm not going to go through it in detail because we don't have time for it, but I strongly encourage to get a better understanding of why this decision is such a poor decision. Read Justice Jackson's dissent. And it's not very long, and it's actually written not in legal mumbo jumbo. It's only about 18 or 19 pages long, which for a Supreme Court opinion is short. And it's really well done, and it's written in straightforward English that a non-lawyer can well understand. So I would encourage you to Google it, look it up. You can go to the Supreme Court website and get all the opinions on their website. And I think it makes a very good read because it expresses exactly what the problem is. If you cripple the ability of the courts to provide a remedy, then the issue no longer is, oh, the court's making terrible decisions. It doesn't matter what decisions the court makes because the executive, in this case, the President Trump, will just do whatever he wants to do because he has the power to do it and the courts aren't empowered to correct it. The courts, in the midst of a situation where we need the courts to engage more forcefully, the majority of 6 on this current Supreme Court has decided to engage more weakly. They've done exactly the wrong thing at exactly the wrong time. With that, let's proceed to the next.
Tom, we have
we have a question from Zoom. Okay.
and another back here. Zoom, can the Zoom,
You wanted to ask.
We're gonna read?
Gonna ask this question.
I don't know.
Or why don't you just ask it for him?
I'm just-
Oh, Casey, do you want to unmute or do you want us to?
Oh, sure. Yeah, I can ask. My question was simply that, there's a lot of talk about them looking at history, but my question is, let's be honest here. Are they looking at history or are they just looking for any possible reason they can possibly find to justify reaching a conclusion that they've already decided they want to reach? I mean, I think of Scalia's so-called originalism, and his selective use of that was really only in line with when it served his predetermined needs.
Well, I think, and it's hard to tell, and that's a somewhat cynical view, but cynicism may be an appropriate tool to analyze the current court, at least the current court majority. I'm not sure what the answer to your question is, but in a way it doesn't matter because their understanding of history is so mistaken and based on so much limited evidence. And it's also based on the false premise in the first instance that the founding fathers would have wanted us to look at a moment frozen in time as the be-all, end-all of the Constitution. I think they understood they were writing a Constitution that could be in force for decades, hundreds of years even. I doubt they would have thought it would have lasted as long as it did. But keep in mind that our Constitution is the result of a failed Constitution, the Articles of Confederation, that was adopted earlier, that only lasted for about 10 or 11 years. So they already had the experience of failure. And I think part of the reason they were vague and general is the hope that on a going forward basis, people would realize the Constitution has to adapt. And I think you may be right that we may have a situation where people are looking back at things and trying to rationalize their view. But there's a wonderful book Professor Chemerinsky's written about the whole concept of originalism and how it's just based on this false premise that you can even know what the actual intent of the founding fathers was. And even if you did know, why should it necessarily be what we're going to apply? I think everybody looks at everything through what they want the result to be, and everyone is trying to find a way to justify their result. And I don't think there's anything wrong with saying, just being honest and saying we can't really understand the intent of the founding fathers, and they wouldn't have wanted us to fully understand it anyway because they didn't keep a complete record. And because of that, we shouldn't be focused on what their intent was. We should be focused on what's the best outcome for us on a going forward basis. And that's the concept. And this is the fundamental ongoing debate that's been going on for decades, if not the entire time of the history of this country. Is the Constitution a living, breathing instrument that allows us all to protect the functioning of our government? Or is it carved on pieces of stone as though it is meant to be unchanging for centuries to come? And obviously, you can figure out which side of that question I'm on based on just how I phrased the question. But I think that's the ongoing debate.
Judge, we have a question from a member back here. Quickly, please.
Yes. With judge shopping for birth control, abortion rights, et cetera, does this decision protect us from a judge who is anti-abortion, anti-birth control, so it doesn't spread?
You know, it sort of does, you know, and that becomes, there is a merit to the point of view that people going to San Francisco or New York or Amarillo, Texas, or Oklahoma City to get a judge, and they then seek nationwide relief for whatever it is they want. They want to get rid of a pill for medical abortions, or they want to be able to have a particular religious program in a school, and they shop. And there's a way to deal with that short of eviscerating the power of the courts. And the way to deal with that is sort of along the lines of the way it's dealt with at the trial court level, where assignments to judges are randomized. But there are already some cases where certain types of cases get 3-judge panels assigned to them. And if you would take the cases that are controversial, be it abortion rights, be it religion, whatever it might be, constitutional protection, and say, we're going to have those cases decided in the first instance by 3 judges randomly selected from across the country, you might reduce the forum shopping that has caused, or arguably caused. Now, they don't say it in their opinions, but I think you're right. You've identified a potential problem. And I don't want to say that there isn't merit to that problem. There is a serious problem with judge forum shopping, you know, to try to get the judge in Amarillo, Texas, for example, I believe is the only federal judge in Amarillo, Texas. So you run off to Amarillo if you have certain stereotypical conservative points of view that you want to have decided in your favor at the district court level. And there's got to be a way to deal with it. And if there were people of good faith on both sides of the question in the Congress, and people of good faith could sit down and negotiate it with each other and come up with the kind of solution I talked about, we might have a better answer than a Supreme Court decision that eviscerates the power of the federal courts.
Tom, didn't Judge Barrett write a scathing personal attack on Judge Jackson's dissent?
Well, I don't know that I would describe it as scathing personal attack, anything worse than the kind of things that Scalia was doing in the past. I mean, they all, and I thought Jackson's dissent wasn't really a personal attack on the rest of the court. It used some pretty harsh words, but I think they were merited by the difference in points of view. And where Bennett is coming from is she thinks that if you have nationwide injunctions, you're turning it, you're creating a tyranny of the judiciary. And I guess what I would say is I don't think she's thought through the question very well. So I don't think it's, I think she's flailing, and her way of dealing with the fact that she didn't have an effective response to Justice Jackson was to sort of badmouth the justice as opposed to challenging her point of view.
There's so much to talk about with just this question, but I think we'd better move on to the next one.
Yeah, I think we have, but this is, like I say, the worst we've had.
I'll turn to you now and ask you, before we talked about the Planned Parenthood case, to give your general impressions on the term this year, and then to speak more specifically about Planned Parenthood versus Medina.
So, I think when Trump came back into office on January 20th, the big question was whether the Supreme Court would function as a significant, meaningful restraint on his power. And I think nearly 6 months in, we can safely say that the answer is no. The Supreme Court instead seems to largely share Donald Trump's expansive vision of executive power. The Supreme Court does not seem to mind most of what I would consider to be Donald Trump's abuses of office. And in fact, the Supreme Court is much more concerned about lower court judges who are trying to stop Trump from enacting the most extreme elements of his agenda. And I think that CASA is a perfect example of this, because in that case, you had sort of two potential emergencies. One emergency is the fact that the president, for the first time since the 14th Amendment was enacted, is trying to overturn birthright citizenship. But the other potential emergency is that 3 district courts are trying to stop the president from enacting an obviously unconstitutional policy. And so the Supreme Court had an opportunity, right? It had a choice. It could have said, wait, this goes way too far. We need to reach the merits and stop this policy immediately. Or it could have said, you know who's really out of bounds here is these district court judges. And it picked the latter option, and it decided to smack down those district court judges instead. And Justice Jackson, in her dissent, described the majority as fostering a culture of disrespect toward those district court judges. And I think that's exactly right, and I think that's what we're seeing. The Supreme Court will tap the brakes from time to time in the Alien Enemies Act cases that I think we might talk about. But in those circumstances even, it seems that the court, the conservative supermajority, is more concerned about preserving its own power, about reminding Trump that it still sits at the apex and that it gets to tell him to stop when it wants to. But even
will they ever want to?
They rarely do.
Okay.
They very rarely do, because they share the same agenda. And I think that sort of segues into the Planned Parenthood case, if I can sort of move into that. I mean, so this is a case that's another perfect example of what Erwin described, of the majority taking sides in the culture war, right? This is a case that is not about abortion, but is also entirely about abortion. It involved South Carolina's effort to defund the 2 Planned Parenthood clinics in the states. The issue here did not directly attach to abortion, because Medicaid dollars do not cover abortions under federal law. As a rule, Medicaid cannot cover abortion services. So when South Carolina said, we want to cut Planned Parenthood out of our Medicaid program, we want to defund it, it was not saying we want to stop the Medicaid funding of abortion, because that wasn't happening. What South Carolina was trying to do was stop Medicaid reimbursements for other services, like STI screenings, STI treatments, cancer screenings, well woman checks, a variety of services that should be uncontroversial, that are not directly related to abortion. South Carolina, the Republican governor, wanted to defund all of those treatments because he was mad that Planned Parenthood happens to also provide abortions. So after he did this, a patient sued along with Planned Parenthood, and they said, wait a minute, you don't get to tell Medicaid patients where they can get services. And that comes straight from the Medicaid statute that Congress enacted, which has a provision that's called the free choice of provider section, which says, in terms so clear that a preschooler could understand them, that if you are a Medicaid recipient, and we will talk soon about how some of these justices do not seem to have the reading comprehension of a preschooler, and this is one example. It says, in clear as day language, if you are a Medicaid recipient, you get to choose your provider. You get to go to a qualified provider, and that provider will be reimbursed for the services that they give you. No one argues that South Carolina's Planned Parenthood clinics aren't qualified to provide all of these other non-abortion services. Everyone agrees that they're qualified to provide those services. So the question in the case was, okay, so can this individual still access those services, or does South Carolina get to cut them off? And the Supreme Court said that South Carolina got to cut them off. The Supreme Court, in fact, said that a Medicaid patient doesn't have a right to vindicate the choice that Congress expressly gave to her in the statute to choose her own provider, because Congress didn't grant that choice in language that was clear enough to satisfy 6 Supreme Court justices. What the court said was, Medicaid is spending clause legislation. It is Congress giving states money to spend in a certain way. And when there is a law of this kind that creates rights, it has to use certain magic words. It has to use the word right over and over again. It has to be crystal clear, even clearer than Congress was in this case, that it is giving a patient a specific right, or any recipient of any service or federal welfare program, a specific right to go to court and sue if they are denied that right. And the supermajority said in this case, that right doesn't exist. Congress wasn't clear enough. But it was clear enough. It gave patients the right to choose their provider. And so the question is, why did the Supreme Court say that it wasn't clear? Why did the Supreme Court say that patients don't have a right? I mean, first of all, I want to say that the consequences of this decision are really, really devastating. It goes beyond Planned Parenthood. It covers much of Medicaid. Because from here on out, if you are denied services under Medicaid or Medicare, if your state or even the federal government tries to cut off reimbursements for Medicare or Medicaid services, you no longer get to go to court and say, wait a minute, I was guaranteed this by Congress. The Supreme Court has taken that away from you. And that goes for a bunch of other spending clause legislation, including education funding, disability funding, all kinds of services. After the Supreme Court decision, you can't sue to vindicate your rights anymore, which seems like a huge problem. And so the Supreme Court only got here by essentially gutting Congress's ability in the first instance to create rights that individual citizens can vindicate. And I think that that shows an ongoing agenda by the conservative justices to say that even if you have rights on paper, you have no way to vindicate them. And we see that in a lot of different contexts of constitutional rights as well. But I think this is another instance of the Supreme Court's conservatives saying, even if Congress tried to give you this right, even if Congress went out of its way to ensure that you could access some service or benefit or whatever, we are going to take that away from you because we don't think Congress should be in the business of creating rights. We're the only ones who get to do that.
This case is sort of a state level equivalent of what we just discussed about at the federal level. And it basically, the language that's at issue here is when Congress said that Medicare recipients are entitled, or Medicaid recipients both, are entitled to see, quote, any qualified provider. And so does that have meaning or doesn't it have meaning? And what the Supreme Court did here is depart considerably from what normal statutory construction is. And I just like the speaker here, I wonder, you know, what exactly does Congress have to say? That you have a right to select, quote, any qualified provider, close quote, and we really, 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 really mean it. I mean, what exactly is required? And just as they took away, the Supreme Court took away a lot of its own power, here it, as a practical matter, has taken away the power of Congress to require that certain federal programs provide certain benefits. If the recipients can't enforce the benefits, what is left for Congress to do? And the way the statute is written right now, and it's going to have to be amended to try to fix this, but the way the statute is written right now, I guess what the remedy is would be that all the state funding in South Carolina for Medicare could be cut off if the Congress decides that they're violating the program, but nobody can vindicate the individual rights of the people who want to use Planned Parenthood. The ruling, again, it's another ruling that makes no sense. It's not consistent with what normal statutory interpretation is, and it's just part of an agenda designed to slash the power of all branches of government other than the executive. Before we go on, any questions or comments on this one?
So help me out here. What's the recourse?
Well, the
I know that-
recourse is at the very beginning, you've got to have a majority in both the House and the Senate. And ideally, you also have the presidency, or you have the position to override a veto, because ultimately what you're going to need to do is change both to fix the prior situation we talked about, the situation of birthright citizenship, if it doesn't end up being upheld. But here, to fix the problem with the statute, these are both statutory interpretations by the Supreme Court. So at least you're not required to get a constitutional amendment to overturn them. You simply have to get the Judiciary Act, in the case of Trump versus Casa, the Judiciary Act revised, and here you need to get the Medicare Act revised. And it's going to require some statutory changes. And I would come back to the point, every time someone says, well, I'm disappointed that the Democrats haven't been able to make these changes, the answer is you have to have a majority in both houses of Congress and the presidency, or you have to have 2/3 in the two houses without the presidency to get the changes you need. And until you get there, you're not in good shape.
We have a question on majority. I just want to say
You need a filibuster-proof majority in the Senate to fix it.
Well, that's right. That's right. You need a filibuster-proof majority, even if you have the presidency. You need that 60 votes. That's how we got Obamacare passed after the recount on Al Franken went all the way to the Minnesota Supreme Court for 3,000 votes, and he ended up being the 60th senator. So you're right. That's a good point.
We have a question online.
Yeah. So I take it that the congressional remedy is to write into the law that people have a right to sue in court to get whatever it is that the Congress wants them to get?
Yeah, you have to be more explicit than they already were. And apparently it's not enough to say individual recipients are allowed to pick any qualified provider. You have to say something more than that. Exactly what more you have to say, you'll find out in future litigation if and when you ever get the law passed to deal with the situation. So it's another very damaging decision, and it's another decision where the Supreme Court is making sort of a mockery of the ability of the courts to control the other branches of government.
Anything else?
Other thoughts before we move on? Okay, let's move on to the next passage.
Jessica, we'd like to hear from you your sort of general impressions of this term, and then to have a conversation about U.S. versus Scrimity.
Sure. So I agree with the themes that have already been mentioned. I want to say another thing, though, about the court's use of its emergency or shadow docket. So I think this is a way that the court is arrogating more power to itself. And in most of these cases that we've seen, the court has let Trump administration policies go into effect after district court judges have said we need to put a pause on those policies to figure out if they're constitutional. So that's concerning. But there's also something that's concerning about it procedurally. So we see on the shadow docket the court making new pronouncements of the law, sometimes with very little briefing or time for full examination of the issues. So I think that's troubling. Another thing that's troubling about it is that the court often comes out with decisions with no reasoning for the public to examine or understand. There is a bright spot on the shadow docket, which is that 9 justices said that people who are going to be deported under the Alien Enemies Act are owed due process of law. That's a bright spot. But then, inexplicably, They didn't seem to think there was due process if the administration had decided to deport them and then decided to send them to a third country like South Sudan or Libya. And we don't know quite why, although we could guess. So I think that's troubling, this use of the emergency docket. I also think another theme is the court choosing sides. So we see that in a lot of culture war issues, the court choosing religious traditionalists over the LGBTQ community, the court neutering civil rights statutes, the court giving the executive a wide berth on immigration. And another theme I think that comes up in the Scrimity case that I want to talk about in a second is empty formalism. So rather than admitting what it's doing, rather than acknowledging that it's making value judgments in hard cases, the court hides behind empty legalisms. So it gives us circular logic. It gives us an invented history or tradition as the excuse for what it's doing. The court contorts texts. It contorts the texts of statutes. It contorts the texts of children's storybooks. It contorts the words of the Constitution. There's a great quote from one of the shadow docket cases from Justice Ketanji Brown Jackson. She said, "Children, pets, and magicians might find pleasure in the clever use of such shiny object tactics, but a court of law should not be so easily distracted." And in that case, she was talking about the use of procedure to avoid substance. So I think this empty formalism is another important theme.
So let's talk about Scrimity.
All right, so Scrimity, United States versus Scrimity. I want to start with where this case began. This is a case that was brought by Samantha Williams, the mother of a transgender daughter in Tennessee. In 2020, after her daughter came out as transgender, the Williams family sought evidence-based health care. There are two forms of evidence-based health care at issue in this case for transgender minors who suffer from gender dysphoria. One is called puberty blockers. So puberty blockers are drugs that are taken by children at the first signs of puberty. They're reversible. They basically put puberty on pause. So the child, the family, and the doctors have time to figure out whether to proceed on to other treatment. So for a transgender girl, puberty blockers would prevent her from going through male puberty. There's another set of drugs as well, hormones. So transgender minors sometimes take hormones. A transgender girl would take estrogen to go through female puberty. The Williams' daughter was pursuing these forms of health care, and according to her mother, she was thriving, happy, and healthy. But during the pandemic, there was a backlash that affected transgender children in red states. Red states began passing laws restricting transgender people from using restrooms consistent with their gender identities, from playing sports, from changing their identity documents, and from pursuing gender-affirming health care. In 2022, a right-wing provocateur held a rally in Nashville where he called transgender identity a delusion. He said that clinics were out to make money on transgender kids and that they were mutilating, drugging, and castrating children. And he told Tennesseans it was a fight of good against evil. In this context, Samantha Williams went to try to testify before a Tennessee legislative committee about how these drugs had improved the life of her child and the lives of other children. But she said they barely acknowledged that she was in the room. They just wouldn't listen. In 2023, Tennessee enacted a ban on puberty blockers and hormones for transgender children, and Samantha Williams, with the help of the ACLU, brought a lawsuit. The case was assigned to a judge appointed by President Trump, Judge Eli Richardson in Nashville. He was persuaded by Samantha Williams' argument. He was persuaded to put a temporary pause on the Tennessee ban so that he could figure out whether it was constitutional. And he decided that it was likely not constitutional. Under the Equal Protection Clause, courts have held that when you have a law that classifies on the basis of sex, there has got to be an exceedingly persuasive justification for that law. This is because historically, when legislatures have gone about passing laws classifying people on the basis of sex, it has not been for a good reason. So, there were two questions in the case. The first one is, well, does this law classify on the basis of sex? If you look at the law, if you read it, you'll see it does right there in the first provision. What the law does is it says puberty blockers and hormones are allowed for all children, except for those who are seeking to use those drugs to live as an identity that the legislature thinks is inconsistent with the minor's sex. That is literally what it says, the minor's sex. So children who are not transgender can use these drugs. Children who are transgender may not. All right then, the second question is there an exceedingly persuasive justification for the law? Well, there wasn't, because there was evidence that these drugs improve the lives of children, like Samantha Williams' daughter. And it's true, these drugs have risks, like all drugs. But the legislature was allowing the exact same drugs for children who aren't transgender. And so it's parents and doctors who should be weighing the risks of benefits. That was a lower court decision. The Supreme Court, unfortunately, for the Williams family, disagreed. The court just did not want to disturb the laws that had been enacted by more than half the states at that time, banning gender-affirming health care for transgender minors. They didn't want to require that those states show that they had persuasive justifications for the laws. Okay then, well, the Supreme Court had to figure out how the law was not a classification on the basis of sex, even though it had a classification on the basis of sex in its first provision. So what they said was, this is not a law that classifies on the basis of sex. It's a law that classifies on the basis of age and medical treatment and diagnoses of gender dysphoria.
And sex.
But wait a minute, right? So the Supreme Court had said you could have laws that classify on 11 different bases, but so long as one of them is sex, you've got to have an exceedingly persuasive justification for using sex, right? So that's one problem with it. The second problem is the law classifies on the basis of the minor's sex. A third problem with this is gender dysphoria is a diagnosis defined based on sex. Gender dysphoria is clinically significant distress that accompanies having a gender identity that's regarded as incongruent with a person's sex. But the Supreme Court will not look underneath the definition of gender dysphoria. It will not see that therein is a sex classification. So that is the holding that we have, folks. There's an upside to this. It could have been so much worse, so much worse. The Sixth Circuit Court of Appeals had a worse rule. The Sixth Circuit Court of Appeals would have said, so long as you have a law that puts equal burdens on men and women, it's not a classification on the basis of sex. So because this law doesn't allow transgender boys to use testosterone or transgender girls to use estrogen, it's not a classification on the basis of sex. Both boys and girls are equally burdened. Now this is a terrible rule because—
That's Plessy versus Ferguson.
Separate but equal. You could say, we're going to make all the girls take home economics and all the boys take shop class, and that's equal burdens on both sexes. So that's a terrible rule. And we wrote an amicus brief arguing to the Supreme Court, please don't do that. And they didn't. They didn't endorse that rule, thank goodness. What we have instead is a limited holding, that when you have a law that singles out certain medical treatments based on gender dysphoria, it's not a classification on the basis of sex. So it could have been worse. That's a limited holding. Now that's the upside, but there's a big downside. The big downside is the Supreme Court just granted certiorari in another 2 cases on transgender rights, Hecox versus Little and BPJ versus West Virginia. And next term, they're poised to decimate what remains of transgender rights under the Constitution, as well as Title IX of the Education Act amendments.
There was another issue in the case, and that involved how should discrimination against transgender individuals be treated under equal protection. Okay. Should it be that the government wins so long as it's reasonable? Or should it be treated like sex discrimination, where there has to be an exceedingly persuasive justification, or even like race, where it has to be strict scrutiny? And interestingly, Chief Justice Roberts' opinion said, we're not going to reach the question because we don't see this law as being discrimination on the basis of gender identity. And that's hard because that's what the law is all about, is discriminating against transgender individuals. But the way he got that is worth focusing on, and I guess I have to use the word contorted here. He invoked one of the most ridiculed Supreme Court cases in history, a case called Geduldig versus Aiello. It's a 1974 Supreme Court case, and involved California saying for its employees it would pay disability benefits for any medical condition that led to disability, but not pregnancy when it led to disabilities. So the state would pay for disabilities that could affect only women, say ovarian cancer, or disabilities that resulted that only could affect men, testicular cancer, but not pregnancy-related disabilities. And the question is, was excluding pregnancy sex discrimination? And the Supreme Court said no. The Supreme Court said there's two categories of people, pregnant persons and non-pregnant persons. Because women are in both categories, it's not sex discrimination. I have not caricatured that. That's exactly what the Supreme Court said, word for word. Chief Justice Roberts in the United States v. Committee invoked Geduldig and says, well, there's two categories of people here. There's transgender individuals who can't have these hormones for gender-affirming reasons, and there's everybody else who can have these hormones for other reasons. He said, since there's transgender individuals in both categories, it's not discrimination on the basis of gender identity. We don't have to decide how it should be treated under equal protection. But I think that there's no doubt where the court's going. Justices Thomas and Alito and Barrett write strong opinions saying only rational basis review. There's another shadow docket case we haven't talked about, United States versus Schilling. It involved President Trump issuing an executive order to bar transgender individuals from serving in the military. Federal district court struck it down on equal protection. The Supreme Court 6-3 reversed that, allowing President Trump to do this. I don't think there's any doubt where the court's going on this, but it's interesting that Chief Justice Roberts wanted to hide it and not be explicit about what the court was saying with regard to gender identity discrimination.
That was interesting to learn, perhaps, that the notion that discrimination on the basis of pregnancy is not discrimination based on sex. I would not have known that. Only very sophisticated appellate level judges would have been able to figure that one out. I don't think there's much to add to this one, except to say that as bleak as the outcome you might feel the outcome is, it really is not as bad as it could have been expected to be, and I don't think it realistically could have been expected to have any different final outcome on this item involving transgender with this current court and with the current political climate. Any questions before we move on to the next section? Questions? Okay, let's move on to the next section.
So my case, Mahmoud versus Taylor, comes from Maryland. So Montgomery County, Maryland, which was one of the largest school districts in the United States, changed its curriculum or introduced into its curriculum a few years ago 5 LGBTQ inclusive books. So some of these books talk about same-sex marriage. I used to read one to my kids when in the book that received a lot of attention in the case. It's called Uncle Bobby's Wedding, and it's the experience of Uncle Bobby's niece Chloe seeing her uncle get married. When I used to read it to my kids and they loved it, I thought it was mice, but Mark corrected me that it was guinea pigs. Right? So Uncle Bobby and his male partner used to be guinea pigs. Now they're humans. I didn't know that because when they reproduce, Sotomayor reproduces a lot of the book in her appendix, and I'm looking at it, I'm like, who are these people? Oh, wow, they made them human. So Mark and I were talking, I wonder if part of the problem, maybe they should have just stuck to guinea pigs. So anyway, so one of the books is Uncle Bobby's Wedding. Another book is about a child whose gender They, Them. Another book is about a trans child, sort of introducing her identity to her parents and how her family responds. Okay, so there were the 5 LGBTQ inclusive books. When Montgomery County, for K through 5, for the K through 5 curriculum, when they first introduced these books, they said to the parents in the, county, in the school, if you want to opt out, kind of like sex education, if you don't want your kid to be exposed to these books, you can opt out, but you have to tell us, and we have to have a sufficient time so we know not to pull the book off the shelf and read it, right? We have to tell you, if you don't want your kid to be there when we read the book, they don't have to be there, fine. The school quickly realized that the opt-out was unmanageable, it was unworkable, and it was unworkable first because, as we know, anyone who has been to a K through 5 classroom, a lot of the time, especially at the younger ages, it's reading hour or reading time is kind of ad hoc, right? The teacher pulls the book off the shelf and just starts reading. So you don't know in advance that you're going to be reading a book. So teachers were like, we just don't have sufficient lead time to know to inform the parents that their kids can have an opt-out. So that was one reason why they got rid of the opt-out. The second reason was they said, look, kids are getting the opt-out and they're leaving the story time circle when they're reading about same-sex marriage or trans or gender non-conforming kids. Well, a lot of our kids have same-sex parents. A lot of our kids are gender non-conforming. A lot of our kids are trans, right? And they're seeing their peers leave the room when they're talking about these concepts, and it's creating social isolation and stigma. So we're going to get rid of the opt-out. Okay, we're rescinding the opt-out, so there's no more opt-out. So at that point, the parents then said, they complained, and they said, by not giving the opt-out, you're substantially burdening the parents' free exercise rights, our religious liberty rights to raise our children according to the religious principles that are part of our religion, right? And the things that they're being exposed to, like same-sex marriage or gender nonconformity or transgender or whatever, violate, they burden us as parents, our ability to raise our children according to the religious beliefs that we espouse. Okay, so they brought a First Amendment free exercise claim against this sort of opt-out refusal. The parents lost, the school won at the courts below. When the Supreme Court decides the case last week, I think it was the 27th, and the Supreme Court ruled for the parents. And the court in Mahmoud says, look, it is a substantial burden on parents' free exercise rights because exposing children to these concepts is tantamount to indoctrination. And that indoctrination, right, runs counter to the principles that the parents want to indoctrinate their kids with, right? So there's this sort of tension. Okay, so how did the court get there? How is hearing a story about former guinea pigs getting married the same thing as indoctrination? So the court, Alito goes line by line through these books. I know the lines well. I read them to my children many times. And says, look, that's indoctrination. That's indoctrination. That's indoctrination. Well, I'll just give you one example. One example that he gives is after Bobby and his partner, his husband, get married, say, I do, everyone claps, right? Yay, everyone's shouting, yay, we're happy. And Alito says that's indoctrination because that is basically saying that same-sex marriage is a good thing. Right, what the author intended there, and he kind of, as a former literary critic, I'm really offended because he's like, clearly that's what the author meant. The author meant this is supporting same-sex marriage as an institution when everyone claps. Not, oh no, we're just happy that these two people found the love of their lives, right, and memorialize that in front of everybody. So he said that's indoctrination, right, and that exposing kids to those stories was a form of indoctrination that substantially burdened the parents' religious practice or religious beliefs, and that the state, in this case Maryland, Montgomery County, didn't have a sufficient justification, right, wasn't able to satisfy that, to justify that substantial burden. So the school loses. What does this mean moving forward? It means a lot of things. It means that sort of this expansion of religious liberty that has been happening on the court for years now just got a whole lot bigger. So it means the free exercise clause has gotten a whole lot bigger. And at the same time, it means that public education, in some very real sense, I think, has gotten a whole lot smaller as a result. Because now it's not going to be limited to these 5 LGBTQ inclusive books, right? You can imagine moving forward, it could be a lot of different subjects to which parents have religious objections that they don't want the teachers teaching the children, exposing the children to exposure as a form of indoctrination. So it's really going to shackle what educators are able to do in the classroom.
All justices, liberal and conservative, come to conclusions and then write the opinions that justify their conclusions. There's no such thing as neutral constitutional law.
Yeah.
It's about values. And so it's not that Justice Alito can't read. He started with a certain perspective with regard to issues of religion and gender identity and sexual orientation, and then wrote an opinion that followed it. It's no different than, in this case, Justice Sotomayor starting with a different view and coming to conclusions that are consistent with that. I think the underlying issue that unites Scrimeti and Mahmoud is one that arises all the time in constitutional law. Who should decide? Let's take Scrimeti as an example. Should it be for the Tennessee legislature to decide what's medically advisable with regard to treating transgender youth, or should it be left to the parents and their children? The majority says, leave this to the political process. Chief Justice Roberts says that explicitly in his majority opinion. The dissent says, because this involves discrimination based on sex and gender identity, it's the role of the courts to look at the evidence and to make the decision. Now, what's in sharp contrast is Mahmoud. The Montgomery County school system made decisions with regard to curriculum. Traditionally, the Supreme Court says we give great deference to school boards when it comes to making choices to curriculum. But here the Supreme Court says, no, we're not going to refer to the Montgomery County school system. If parents believe that exposure of their children to the material violates free exercise of religion, they have to have notice and the ability to opt out. So there isn't the deference to the political process in Mahmoud that there was in Scrimeti. And both cases raise really difficult issues of where's the stopping point? In Scrimeti, is there going to be any judicial protection for transgender individuals when you see that what the Trump administration is doing, or what you see in terms of now trying to talk about blocking transgender care for even adults? Will there be any protection under the Constitution? And on the other hand, when you get to Mahmoud, Justice Alito's opinion had no cabining principle. Any parent who objects to anything on religious grounds now has the right to opt their children out. So when it comes to teaching biology or science where there's evolution, parents say, exposing my children to that, I have the right to opt my children out. If it's an English class where they're studying Harry Potter or The Wizard of Oz and there's witchcraft, parents have the right to opt their children out. If there's images of how people are presented that's inconsistent with their religion, the right to opt their children out. Both of these cases raise really difficult issues in terms of what's going to happen in the future.
So I do want to ask a question about some form of agreement or harmony on the court, right? So we at least had 4 or 5 cases this term where there were 9-0 unanimous opinions. The TikTok case, right, was a 9-0 per curiam. The Smith and Wesson, the Mexico government wanting to sue U.S. gun makers. Ames versus Ohio Department of Youth Services, which is about what you have to prove if you're a majority member for an anti-discrimination suit. Barnes versus Felix, which is that, the moment of threat doctrine and what you consider in the totalities of the circumstances for a police shooting. Do those cases tell us anything about the places on where justices either have some sort of shared values or shared, interpretation about either their own role or the doctrine, or is it just in any set of cases you will find a handful under which, for various reasons, they can come to some sort of agreement? Because it wasn't all a 6-3 term. Yeah, Erwin?
There are always a certain number of decisions that I'd refer to as error correction cases.
Okay.
The lower court got it wrong, and the Supreme Court's going to step in and say so. Take the Ames case that you mentioned. The Sixth Circuit implied that a person who was from a majority in that instance, sexual orientation, would have a higher burden to bring an employment discrimination suit than somebody who was gay. And I think it was predictable that the Supreme Court would say, as it did in Justice Jackson's opinion, no, the same burden for employment discrimination exists whether you're in the majority or the minority. Or your example of Barnes versus Felix. The United States Court of Appeals for the Fifth Circuit said, when there's excess of police force, focus only on the moment it happens. Don't look at the surrounding circumstances. That's absurd in deciding whether or not the officer acted reasonably. The Supreme Court corrected the error in that easy case. I think the fact that the Supreme Court has about 40% of the docket where it's unanimous doesn't tell us very much about the court, because those aren't the hard cases. Those aren't the ideologically divided cases. I think that to really understand the current court or any court, you have to focus on the other cases.
The Mahmoud case may remind some of you, if you remember some of the earlier presentations from earlier years, the wedding cake case, and the issue of, if you're doing business, can you be forced to do business with people you don't want to do business with? And this is sort of a similar question. Can you be forced to have your children exposed to things at school that are not consistent with their religion? And in a way, you may say, well, I should be able to do that. I should be able to essentially thoroughly set whatever it is my children are going to learn at school. But the problem becomes one of practicality, I think. The problem becomes one of, if that's how the decisions are going to be made, that it's everyone's free exercise of religion is threatened by everything that's taught in school. You're not going to be able to teach much of European history, because much of European history is religious wars, and one side or the other might be offended by the outcome. You can't teach evolution. You can't teach, arguably, maybe you couldn't even teach that the Holocaust took place in history classes. Maybe there would be some people who would be religiously offended by that in some manner. So you end up with this whole concept that free exercise clause in the First Amendment, free exercise of religion, is being interpreted in ways by the Supreme Court that it's becoming so expansive that it's becoming impractical. We can't have civil rights laws anymore because people say, look, I don't want to make a wedding cake for someone who's gay. I don't want my children being taught that the earth is not flat. Whatever the issue is, we are going to have something that's very impractical. You're going to, every time you teach a lesson in a school, you're going to have to say, oh, is there anyone who has to leave here? Or you're going to have some sort of record keeping, and kids will be leaving class, coming back in, leaving, coming back in, depending upon exactly what it is that's being taught. Before we go on to the final discussions, any questions or comments on the Mahmoud case? Yes.
I just want to say, what's your name? Steve Goldsmith. When I grew up, people had the religious belief that blacks and whites should not be going to the same school. So I think it would undermine brown.
Yeah, exactly. That would be another example of, if they say my free exercise is that I don't think my kids should even be in an integrated school, are they then allowed to say, put my kids somewhere else? I don't think this court would go that far, but then I wouldn't have thought this court would have allowed people to be deported to countries in the midst of civil wars either. So there you go. Other questions on this?
Judge, I have a question.
Shoot.
This is a very important review, I think, because in the 15 years that you've been doing this, because it's the first review that covers the first part of the second term of Donald Trump, in which is the character of the presidency that is completely different from the first time. This is a very aggressive, very transformative in a bad way presidency. The through line that I've seen of these cases looks like this. As servile debasement of the Supreme Court in service to the Trump political agenda. The first case, birthright citizenship, and outrageous. I mean, the birthright citizenship is just flatly in the Constitution, and challenging it is just outrageous. But it's done in servile debasement to the Trump political agenda because it's about immigration, and that's the central theme of his presidency. The second one, Planned Parenthood, is in service to his fundamentalist Christian backing. The same applies to the transgender issue. And then the Mahmoud case is the same thing. We're going to see how the rest of this goes, but am I wrong about this? This is not what the Supreme Court is supposed to do.
Well, unfortunately, I think you're probably not wrong. I guess I would have said, and I said in prior years as we were evolving toward this, I think we have a Supreme Court of 9 that is sort of split into conservative faction, liberal faction, and authoritarian faction. And I'm wondering if that's even eroding further. I don't think we would have gotten decisions like Obergefell, gay rights and marriage. I don't think we would have gotten that decision in a Supreme Court like we have now, where Justice Roberts is no longer the deciding vote. I think one thing about the Chief Justice is he likes to be in the majority. And in the past, at least for a while, certainly in Trump's first term, before we had 3 Trump appointees all confirmed, that there were times when Justice Roberts could throw his weight with either side of the political spectrum in the Supreme Court, and it would be the deciding vote. And so he could vote in ways that meant that the Supreme Court was not entirely in service of Donald Trump's political interests. He no longer has that power. And in fact, I would say the most powerful person on the conservative side of the court is Clarence Thomas, or at least Clarence Thomas has the prospect of being the most powerful because he's the most senior. And unless Justice Roberts votes with him, he's the one who picks who gets to write the opinions of the court. So why do you think Chief Justice Roberts is voting with him? He knows that if he votes with 3 liberals, he's just going to be in the minority. Not that he would be inclined to vote with them all that much anyway. But now he would just be giving up his power to dictate who gets to write the opinion of the court. Why should he give that up? Why doesn't he just go ahead and vote with the majority? And here, every single decision, 6-3, 6-3, 6-3, the liberals voted one way, the authoritarians and the conservatives voted lockstep the other way. There doesn't even seem to have been a realistic possibility to win over the conservatives. One of the justices, Barrett, whom I think of as a conservative, and I've thought I made comments last year, I thought, there was some hope in some of her opinions.
Agreed.
And I wonder after this season, this term of the Supreme Court, whether there really is any hope for her and Kavanaugh. Are they just, and Roberts, are they just all going to be lockstep with the authoritarians? And the distinction I was trying to draw between the authoritarians and conservatives maybe just doesn't really matter anymore.
It just seems so transparently obvious, underlined by the fact that they're trying to conceal it by using the shadow docket.
Well, yes, to some degree, I think that's right. I mean, the shadow docket, I think, is also a result of just not taking the time to decide more cases.
Lazy.
Or just taking the time to sort of manipulate the outcome in a case, but not putting the energy in to be intellectually honest and write a real opinion.
Do we have any questions further?
We probably
Anything online?
We need to move on to
10 more minutes. Let's proceed.
Go ahead.
I'd just like to add, though, that I was heartened that 9 justices agreed that you are entitled to due process of law before you are deported.
But then didn't do anything to give them a measure of due process after the fact. Unless I'm wrong, you can correct this.
It feels like the bar is on the floor when we're trying to come up with something nice to say, and it's that immigrants get due process. And then, as I think you're implying, Mario, just not long after the court said that immigrants get due process in deportation proceedings, said that once they've been rendered deportable, they can be sent off, expelled to third countries like South Sudan that they've never stepped foot in, where they might face torture and death without any further due process. And so the court giveth and then taketh a lot away. But I want to just focus on some of the cases you just mentioned, because I do think those are areas where the Supreme Court's liberals do their best work. Because almost all of the cases you mentioned, those were actually majority opinions by liberal justices. And part of what's going on there is that the liberal justices have to do something other than simply dissent all the time. They have to write majority opinions from time to time. The court tries to distribute the cases fairly evenly. And so cases like Ames go to Justice Jackson. And she used that decision not only to do the error correction, but to pretty emphatically reaffirm that Title VII of the Civil Rights Act does protect gay employees. Yes, in this case, it involved a straight employee who claimed that a cabal of evil gays at her workplace was out to get her. Yes, it's kind of weird that the Supreme Court had to rule in her favor in a unanimous opinion, but Justice Jackson was able to take advantage of the opportunity in that case to say, but by the way, just as it protects straight people, it also protects gay people. In another case, Catholic Charities versus Wisconsin, this was about whether certain charitable organizations get a tax exemption for their charitable doings, even if they aren't proselytizing to the people who receive their services. And the Supreme Court said yes, and Justice Sotomayor wrote that opinion, and she used the opportunity to try to revive the Establishment Clause of the First Amendment, which protects the separation of church and state, which has been under relentless assault from the conservative majority for years now. But Justice Sotomayor rooted the decision very much in the idea that discriminating against certain religions based on their practices and favoring others violates separation of church and state. We have to treat all religions equally. We can't give any special favors. And so I think it shows like the liberal justices are thinking strategically in these small fish cases about how they can try to develop the law and press the law in a direction that they like, that they favor. The problem is that there's only so much they can do, because when a big case comes along down the road where the conservative majority wants to make a move, it makes the move immediately. When the conservative majority wants to take the Establishment Clause out of the First Amendment, it's just gonna do it. It's not gonna care that Justice Sotomayor wrote this wonderful opinion reiterating that the separation of church and state exists. They're just gonna take it back out in the future. And I think I'm actually curious to hear what our co-panelists think about the role of the liberal justices right now, because it feels like a very difficult position to be in. When do you take advantage of a majority opinion to try to plant some seeds for liberal decisions or reaffirm liberal doctrines? When do you dissent in a really harsh tone that castigates the majority? When do you pull punches today? Because doing so could help you build future coalitions tomorrow. I think this is something that all three liberal justices are approaching in different ways. Justice Jackson is ready to burn the place down, God bless her. Justice Sotomayor is sort of like trying to make compromises sometimes, but standing her ground. And Justice Kagan is often signing on to what the conservatives are doing here. And I think all three approaches have their merits, but they all run into the problem that being in a three liberal justice minority sucks, to put it in legal terms, and that each of them has extraordinarily limited power to move the court in any particular direction.
I very much agree that the three liberal justices see their role differently. I apologize, but I don't think Justice Jackson wants to burn the house down. I think Justice Jackson is writing for the press and the future, and very consciously doing so. I think she regards herself as having a very important voice, and she's going to articulate. I think it's completely appropriate for her or any justice to do so. That's why I thought the Adam Liptak article in the New York Times that said, well, Justice Breyer said it took him 3 years to get experience, and Justice Frankfurt goes, Justice Brandeis saying it took him many years, which implies Justice Jackson shouldn't be speaking now. I think that's completely inappropriate, and I think she's very self-conscious of her role. I think so is Justice Sotomayor. And it's interesting, when Justice Ginsburg was on the court and she dissented, she believed that she should write the sole dissent and that the other dissenting justices shouldn't write separately. So if you look at cases like Shelby County versus Holder, Justice Ginsburg writes a very powerful dissent and there's no other dissents. I think Justice Sotomayor would like that role, and she writes so many of the prominent dissents. I don't think Justice Jackson agrees with that approach. I think Justice Kagan, though, does. Justice Kagan hasn't written the same kind of powerful dissents this term as Justices Sotomayor and Jackson. She wrote a dissent in Free Speech Coalition versus Paxton, a case about requiring age verification for minors having access to websites, but it wasn't the kind of dissents we saw from Sotomayor and Jackson. I think there's another thing that I think Kagan sees her role differently. I think she's much more trying to be in a conciliatory role. There are more cases where it's 7-2. Last week when the Supreme Court again said that the Trump administration could send people to South Sudan, Kagan joined with the conservative justices. It was Sotomayor and Jackson who were dissenting. So I think they see their role differently, but it's easy, and I agree very much with you, to understand how difficult it is. They care deeply about these issues, as do the conservatives, and it's really hard on the issues you care a lot about to constantly be on the losing side.
There are a number of cases on the docket already, the shadow docket, for which if the federal government is denied its way, there are questions as to whether it will observe the rule of law and comply substantially. And my students, I'm teaching wonderfully, I'm teaching undergrads this summer. My students said to me, well, what is the mechanism we use to ensure that the president complies with federal, judges? And I didn't want to say, but, voluntariness. And your oath of office and the faith and fidelity you have for the rule of law. And so my real question is, Justice Roberts seems to be fretting mightily for the day when there will be a constitutional crisis around a disavowal or a refusal for the current administration to comply with a Supreme Court order. And I wonder whether we think we are on the precipice of that moment. And then more generally, if not that question, what do we think about the upcoming term in terms of either the shadow docket or at least I know you've already told us, Jessica, about 2 more trans rights cases are on the horizon. So
I'll just say briefly, I think that John Roberts is playing an incredibly dangerous game that he's going to lose. Okay, let's just be clear. This administration has repeatedly violated district court orders already. That is not in dispute. That is a fact. This administration has deported people, put people on planes, impounded /funding and appropriations in direct violation of federal court orders over and over again. And in multiple cases, the Supreme Court has rewarded it for doing so. In multiple cases, the Supreme Court has given relief to the Trump administration from district court orders that the administration had defied, had flouted. That was true most recently in the South Sudan case, where a judge said, don't put people on a plane to South Sudan, this is an order, and the administration put people on a plane to South Sudan, and the Supreme Court said, that's fine, send them off, no problem. And I think that John Roberts and Justice Barrett and Justice Kavanaugh, they think that they can throw these district courts under the bus, but that the administration will still respect their court when they want to draw the line. And that is something that the president himself has said repeatedly in interviews, that he doesn't really respect district courts or lower courts, but that he'll respect the Supreme Court. And I simply do not believe that when the time comes, and it will come in my view, that the Supreme Court says no to Trump, and he doesn't want to stop doing what the court has told him to stop doing. When that moment comes, and it'll be sooner rather than later, right? We're not even 6 months in, folks. We've got a long time to go. We are barreling quickly toward this crisis. When that time comes, now that the Supreme Court has over and over again blessed the administration for violating court orders, what in the world is going to make Trump think differently about the Supreme Court? And I think the answer is nothing. And so I think that the Supreme Court thinks that it can endlessly sap the power of the lower courts without sacrificing its own authority. And I think that it will learn soon enough that it is badly mistaken and that it is giving Trump permission to treat it as just another layer of bureaucracy that Trump can blast through when it stands in his way.
Erwin? I think the record of the Trump administration complying or disobeying court orders is a little bit more complicated than that. I argued a case in federal district court in Northern District of California in San Francisco on June 20th. There's a class action suit on behalf of all of the faculty and researchers in the University of California who had their funding cut off. The judge, Rita Lind, 3 days later, on Monday, June 23rd, ruled in favor of the class and ordered that the money be restored. And by our count, over $100 million of grants have been restored since the judge issued the order. I don't know what will happen on appeal. I don't know that all the grants will be restored, but certainly some have been restored. With regard to Trump versus ARP, the Supreme Court said no additional people can be taken to El Salvador until further court order. And the Trump administration has complied with that. There are also, as you say rightly, many instances of the Trump administration disobeying court orders, and the rhetoric is inconsistent. There are times when the rhetoric has been, we're not going to pay attention. Remember Donald Trump put out, he who saves the country violates no law. There's a direct quote. J.D. Vance has said on many occasions the president doesn't have to follow court orders. But there are also instances where President Trump has said he will comply with Supreme Court orders. I agree with your student's question, because ultimately, if the government wants to disobey court orders, there's almost nothing that can be done about it. In terms of criminal contempt, the president can pardon for criminal contempt. In terms of civil contempt, well, the United States Marshals enforce civil contempt, and they're under control of the Justice Department. And if we get to the point, and you might be right that we will, that the president can ignore the Constitution and then ignore court orders, then no longer are we a democracy under the rule of law. Because then the president can do literally anything. Send me or you or any of you to El Salvador, and no court would have any authority. No, none of us do. But then we are no longer a democracy under the rule of law. And the fact that we're talking about it should be of concern, but I don't think we can know at this point where it's going to end up.
So I agree with these last two comments in particular. A lot of what the administration is doing is political theater.
Yeah.
They've achieved a lot of their purposes. I think the dissenting justices, Sotomayor and Jackson, are trying to send us a political message. The court, it's been said, is the least dangerous branch. It doesn't have armies. It doesn't have funding to pursue priorities. John Roberts has said that the justice he admires the most was the first Chief Justice, who made the Supreme Court what it is, who took it out of the basement of the Capitol building and made it a third branch of government with equal status, despite not having the kinds of resources of the other branches. And he's going to do everything he can to protect that institution and its power, even if that means backing down to the Trump administration. So that means if you don't like what the Trump administration is doing, you cannot rely on the Supreme Court to stop them. You have to organize, you have to vote.
Well, on that note,
Yeah, and I guess I would say I share the pessimism just articulated, although I guess Professor Chemerinsky is being somewhat optimistic and sensing that maybe we won't have a constitutional crisis. But the main reason I would say I think there's a reduction in the probability that we will have a constitutional crisis over the last year or so is that the Supreme Court has become, in my view, less and less likely to deny the Trump administration anything it wants. And so if it gets everything it wants, there isn't going to be a constitutional crisis because it's not going to have to disobey any court orders. If all that happens is every now and then an individual litigant is able to enforce his or her rights and the administration decides, okay, that's a minority of people, we'll just follow the court orders in those regards. And as to the more broad questions, there are no nationwide injunctions, so we don't really have to worry. Then there's much less likely to be a constitutional crisis that the Trump administration will care about, and therefore we won't face that. But I don't think that means we remain a democracy when we have a situation where the rights cannot be enforced across the entire class of people, like everyone born in the United States can't be assured that they are still a citizen without bringing their own lawsuit. We have a situation where we really already, in many respects, are not a democracy anymore. Questions, thoughts?
Yeah, hi, Boyd Lebo. I'm curious, I'm old enough, as many people are in the room, to remember Nixon's presidency and the concern about the imperial presidency. And it sounded like from your remarks earlier that, and I don't want to put words in your mouth so you can clarify this, that there seems to be kind of a guiding philosophy of the conservatives in the court that presidential power is kind of supreme. If that's accurately a summary of what you're thinking, can you say why? Why do you think they have that point of view?
I wish that's a key question. I wish I knew the answer to that question. Like you, I remember the Nixon presidency. And in fact, I won a speech contest in my junior year at high school. I'm going back for my 50th reunion in September of this year. But I won a speech contest calling for Nixon's impeachment when I was a junior in high school. And I memorized large passages of the Watergate tapes, including, quote, $1 million, we can get that. We can get it in cash. I know where it can be gotten. It won't be easy, but it can be done, close quote. Now, there were a few ellipses in there because one of the statements was a few pages in front of the other, but they were clearly related to each other. And what's happening now is, in many respects, so much worse than what happened under Nixon. I mean, all Nixon did was help participate in a cover-up of a politically motivated burglary. I mean, that's, people didn't say the election was stolen. Nobody stormed the Capitol. Nobody attacked anybody. There wasn't the whole panoply of things we've had in the last 10 years. There was nothing even remotely close to that. But there was a difference in that the political party supporting Nixon at the time didn't support him when he wandered off the reservation. There were certain conventions that were still accepted, and those conventions have dropped by the wayside. And one of those conventions was respect for the court system, which has kind of dropped by the wayside. We didn't have, until Trump, we didn't have a president who consistently and regularly attacked every judge involved in every case that made a decision that was in any way adverse to him. We didn't have that at all. I don't even remember significant, back to when I was a kid, I don't remember significant situations of presidents criticizing courts generally, much less criticizing particular judges. It just didn't happen. Well, that taboo, whatever it may have helped us have, and whatever problems it may have avoided, which I think is a lot, that taboo is gone. So I don't know the answer to your question, but we've got to figure it out.
We have a question here.
Yeah, I was wondering why they didn't touch on the EPA decision, the Chevron, whatever it is, because that takes away the rights. And I think following the money is, it might have been last year, but it's part of this whole piece of stripping away and particularly unleashing industry.
Understood. Yeah, they just picked the 4 cases I think they thought were the worst.
Okay. Speculative, but is it possible that Kavanaugh and Roberts are trying to prevent a constitutional crisis when they go along with these extreme decisions?
Maybe. I'm not sure. All I know is I'm disappointed because I thought we had sort of a 3-way split, and that there were 3 conservatives, 3 authoritarians, and that the 3 conservatives were people you could maybe bring along depending upon the issue, and there were cases that were being decided that way. And this term yielded much different results than that, and I think sort of crushes that hope that you're expressing, which I shared a little bit.
Judge, when we were putting this together, we got into a very interesting conversation. Rachel Maddow has described the Trump presidency as a consolidating dictatorship. You have said that we're facing a situation where we may not have a democracy anymore. What would you say is if we do have if he consolidates the dictatorship, we obviously don't have a democracy anymore. What would you say the scale of the crisis we face is today?
I don't even know how to scale it because I don't have enough of a perspective of history to go all the way back, but I would say it's got to be at least somewhat similar to what Germany was facing in the late 1920s, early 1930s. Now, I'm not saying the motive of the consolidating person who's trying to become a dictator is as evil as the motive of Adolf Hitler. I'm not saying that at all, but I'm just saying that you have a situation where the legislature, we don't have a parliamentary democracy, so the legislature's power over the executive is very limited. In the past, we seem to get by with relatively poor legislative oversight of the executive branch because we had a considerable amount of oversight by the judicial branch. That is dropping by the wayside. So we have an executive branch that is largely unrestrained. And the question then becomes, what will it decide to do with that lack of restraint? We know one thing, it will go through the ranks of all the federal government employees, find everybody who opposes its policies and fire them all. That much we know. And the question is, what else will they do? And I don't really know. And it's outside of anything I've really seen that has been applicable to our government or the government of England, from which our judicial and legal system and governing system sort of evolved. And so it's unprecedented, and I just don't know where we're headed.
Do you agree with the final speaker that what we need to do is organize, participate in groups like this, and use the power we do have to vote and change?
That, and we have to see if we can reach across to others with different views of our own and at least figure out, is there any consensus on anything? In other words, is there any limitation? Is the current executive so respected by his supporters that he could, for example, go down on Fifth Avenue in Manhattan, pull out a gun and shoot a bunch of people, and his supporters would say, that's just fine?
Yeah, that question is, I'm afraid I know the answer to that. Thank you. I'm going to turn it over to Tim to wrap things up. And thank you so much, Tom.
Thank you. Thank you.
And again, thank you to Judge Long. Thank you to Reggie and Lewis and Ann and Carol, working with Judge Long to put together this presentation. Although it was ghastly, some of the things that are going on, the information is something that we need. And obviously, as we adjourn the meeting, I think that we're realizing that it's up to us. Nobody's out there going to come to our rescue. It's up to us to protest, be active citizens, and resist what's going on if we're going to turn the tide on this administration. And we must win the House next year. So again, appreciate everybody's attendance. Appreciate that people stayed out, even though we went a little bit overtime today. And our next meeting will be Sunday, September 21st, right here at 2:30. Yes, thank you, Judge.